welcome to City of Charlottetown Presents Podcasts for Seniors. Today, our guest is Hannah Jones. She's the Community Liaison with Community Legal Information. This is going to be a good one. Pay attention closely, and we'll all learn together. So, Hannah, tell me about yourself. What do you do, and how did you get into your current job?
Well, I have worked at Community Legal Information for not quite a year. My role here is as the community liaison. So I do a lot of outreach in the community with different organizations and really helping people in the general public to learn about laws and understand them and how they can impact them, and providing a lot of resources too. So I have a background of 10 years of work experience in the nonprofit industry and really working in a lot of client service. So this was a nice natural progression for me to come over to Community Legal Information.
Great. So tell me, what is the difference between a will and an estate?
A will is a legal document that you are making where you get to describe exactly what you want to have done with your estate after you have died. So with all of your possessions, all of your valuables, any property or homes, anything like that, how do you want that to be distributed after you have passed away? And really, in simple terms, I often like to describe a will like an instruction manual for your estate. So the second part to your question is what is the estate? That really is all of your property that you own. So the personal items, any financial assets that you have, as well as real estate. So the two items really go together.
So what types of wills are accepted on Prince Edward Island, and what are the rules for making your will?
Well, I'll start. There are actually 3 different types of wills that are accepted on PEI legally. So the first one is a handwritten will. That's anything that you will write down yourself. Sometimes you may actually hear that being called a holographic will. But a handwritten will is definitely legally accepted on PEI. You could also use a will kit, and that's something that you can purchase at larger stationery stores. And when you're purchasing those, they give you some instructions and some guidance on the types of things and how to complete the kit. Just one note that we always like to point out, if you are purchasing a will kit, to make sure that you're purchasing one that's valid in Canada. And then the third option, and certainly not the last option, and it's one that we do definitely recommend to clients, is having a lawyer create your will for you. They really have a lot of experience in creating wills, and as well as the experience of dealing with a will and an estate after a person has passed away. So they know all the extra tools and the extra things to think about when you're creating a will. Now, going to the second part of your question, what are the rules for creating your will? There are really 3 primary rules. And the first is that you need to be at least 18 years of age. You also need to be competent. So what that means is that you have the mental ability to make and understand legal and financial decisions. So that's being able to make those, but also be able to act upon those. And then the third one is that when you're creating a will, no matter how you are making it, it needs to be properly signed by you and 2 witnesses. So what that means is that all 3 of you have to be together when you are signing the will. And especially important that the witnesses, they cannot be beneficiaries of the will. So they can't be receiving any kind of gift from the will. And one extra little point is that they also cannot be the spouse of a beneficiary. So that's just some extra helpful tips to know about that for making your will.
What should be included in a will, and how often should a will be updated?
In answering the question, I'll start with the first part to the question. And what's really important that must be included in a will are the names and contact information of all of the beneficiaries, as well as all of the dependents. So that's anybody who you are leaving a gift to, as well as on the list of your children if they're under the age of 18. You also want to leave a list of your debt. So that is things like mortgage or credit card debts or car loans, anything like that, anything that you are owing money on. You also want to have a big list of all of your assets that you have. So that could be real estate and property. It could be a boat. It could be any investments that you have, a list of any and all of your bank accounts, anything like that. So having that list makes it really accessible when the time comes for somebody to deal with your estate. You also want to list the names and contact information of the executor. So this is the person that you are assigning to look after your estate. And finally, you also want to list a guardian and trustee if you have dependent children. So those are kind of the primary things to include when you are creating or even if you are updating your will. Going to the second part of your question of when should you update your will, it's really important that you update your will anytime there are major changes in your life. So we like to say and suggest items like if you are getting married or if there's a separation or a divorce, if there are any major life changes, maybe changes in the makeup of your family, if more children are born, if your children age out and become adults. Also, if you have a very significant financial change, that's also a good time for you to make an update. It's especially important too if you know that you update your will, especially if you're moving to another province or to another country.
What's the difference between beneficiaries and dependents?
This is a great question, especially because I've been using these two terms already. So beneficiaries, that's any person or any group of people who you are leaving a gift to from your will. So in your will, you are writing in there exactly what you are wanting to give and how you want that to be distributed to different people. So those are your beneficiaries. Beneficiaries, you get to choose whoever they are. It could be children, it could be friends, it could be a community organization, it could be an academic institution. You get to decide how you want that to be distributed. Your dependents, as I've kind of mentioned already, that's really anybody who relies on you for any type of financial support. Most often we think about children who are under the age of 18.
All right. So what is an executor's role and how do you go about naming an executor?
Well, I think I'll start with the second part here in terms of how do you name your executor. It's actually really important that you name more than one executor. And the reason for this is that if something happens to one of those people, then you have a backup person already in place. So when you're naming an executor, it's really important that you have a conversation with this person. Ask them if they would be willing to take on this role. And really, this role only starts when you have passed away. And what they will be involved in doing then is they're going to be arranging your funeral and burial arrangements. They're going to be gathering all of your assets. They're also going to be going through the process of paying all of your debts and taxes, applying to the probate court, and importantly as well, they'll be distributing your estate based on your descriptions in your will.
All right. So what happens if you die without a will?
Well, this is actually a really common occurrence that does happen. And when a person dies without a will, it's called dying intestate. And so without a will, it's really as simple that you haven't left any type of instructions of what you want to have happen and with your estate or how you would like that to be distributed. So what has to happen in that place, because there's no executor that is named, somebody who is really close to you, like a spouse or an adult child, somebody who has a really strong connection with you, would have to actually apply to the court to become your administrator. So the administrator will do very similar tasks to what the executor does. It's just that they don't have the instruction manual to follow. So they have to know you quite well and understand what your best wishes and your best intentions would be.
What's the difference between an executor and an administrator?
Well, I did just kind of touch on this a little bit, but I think it's important to clarify. So the executor is somebody who you are assigning when you are creating your will. And again, you can name more than one person, and it's actually recommended to name more than one person. they're going to be following your will and carrying out the instructions of your will. An administrator is very similar to an executor, except they have to apply to the court. And this only happens if you die intestate or if you die without a will.
What is power of attorney?
So we're kind of shifting topics at this point. So power of attorney is a legal document where you are assigning the powers to somebody to look after your legal and financial affairs. And so this is when you are living. This would be in a situation you're planning ahead. Maybe there might be a circumstance where you are not able to do these things for yourself. And so you are assigning this for somebody else to help you with that when you are not able to do those things for yourself.
When would someone use a power of attorney, and who should you choose to be that person?
Well, I guess what I'll start off with is saying, as I just mentioned, it is a really great idea to have this in place. We never know when we might have some kind of, traumatic event in our life, or some situation might happen where we're no longer able to make those kinds of legal or financial decisions. And so having this in place is really important so that those things can be cared for when you are not able to do that. And so in terms of who should you name, you're actually naming a person or assigning a person to be your attorney. So you're always wanting to pick somebody who you trust, who you know that they're pretty good at handling financial or legal matters. The person must be at least 18 years of age. They must also understand what are their duties or what they're going to have to do to be your attorney and what their powers are. And they must also be competent. So they must also have the ability to make and understand financial and legal decisions. So just to carry on from that, though, it's really important to mention that there are 3 different types of power of attorney. So specific power of attorney is when you are assigning somebody to do one specific task. And I sometimes use the example of, maybe it's somebody who physically isn't able to do the process of selling their vehicle, but they're assigning a friend or a family member to be their attorney to look after that one specific task. And as soon as the task is complete, then their job or their role as the attorney, that's over. The next type of power of attorney is the general power of attorney. So if you are starting this and you create this today, it comes into effect and you are assigning somebody to be your attorney, and they're going to be able to help you with your legal and financial affairs. The one that I think a lot of people are wanting to get in place, and it's really important to get this one in place, is enduring power of attorney. So what this one is you are making and setting up your enduring power of attorney today, but it only comes into effect at the time when you are deemed as being incompetent. So that an example of that would be if a person has been deemed as having dementia or Alzheimer's, and they don't have the mental capacity anymore to be making their own legal and financial affairs. So if they have this in place, then that person can help them with their day-to-day banking or doing other things that they need them to be doing for them.
Okay, so how do you write a power of attorney, and how can you change or cancel a power of attorney?
So I'll start by answering, how do you write or how do you create your power of attorney? The first thing that's quite important is that you must also be competent when you are creating your power of attorney. Again, that means that you must be able to understand and act upon legal and financial decisions. The document is a legal document, so that means that it must be signed, dated, and witnessed. And what's very important is that you create a list of exactly what you want your attorney to do or not do. And that can provide you with some extra kind of security to make sure that that person is doing exactly what you want them to be doing or to not be doing, and not have them take advantage of you in that way. we always recommend that when a person is planning to create their own power of attorney document, that they first talk to their bank or their financial institution, because sometimes those banks and financial institutions will actually have their own power of attorney document. So have a conversation with them first. It's also really valuable for somebody to speak with a lawyer, just to get advice on creating their power of attorney, or they could also hire a lawyer to write their power of attorney. And the extra option there is that at Community Legal Information, we actually sell power of attorney kit for $30. So that also makes it quite accessible. So I'll shift into the second part of that question about canceling or changing your power of attorney. Really, you can do this at any time that you want, as long as you are still competent. So the steps to take are that you need to notify the person who you've assigned as the attorney in writing. That document must be signed and dated. So you're really notifying them that they're no longer your attorney. They won't be allowed to act as your attorney anymore. You also want to notify all of the organizations or financial institutions anywhere where that attorney had been acting on your behalf about your legal and financial affairs. Again, that document needs to also be signed and dated by you. Now, in terms of changing your power of attorney document, it's really like you'll be creating a new one. So that's really how you're going to be changing or updating.
Okay. So what is a healthcare directive and what should I include in my healthcare directive?
A healthcare directive is another legal document, and it's one that you use to explain your healthcare plan as well as your treatment decisions. This really is used by medical professionals if you are not able to communicate those things yourself. For example, if you've arrived in hospital and you're in a coma, or perhaps you are in surgery, there could be a whole variety of situations where maybe you're not able to have that type of communication. And so this document tells the medical professionals what you do or do not want to have done. In terms of what you should include, I think of this as a lot of kind of the who, where, why, what, and when. So who do you want to look after your healthcare decisions for you? Really, it is going to be the medical professionals. But when you create this document, the healthcare directive, you are assigning a person as your proxy. And that person is really going to be helping to communicate what your directions are to the healthcare professionals. The when, that would be, when do you want this to come into effect? When do you want this to start? What includes, what are the treatment options or the procedures that you do or that you do not want to have done? And another when is also when you would like to die a natural death. You can indicate that on there as well.
What happens if you don't have a healthcare directive?
This is very, very common. And what happens in this scenario is that medical professionals will sign or choose a substitute decision maker to help make those decisions on your behalf. This substitute decision maker should be somebody who knows you quite well and somebody who understands your values and your beliefs. And especially helpful if they know a bit about your medical history too. So when medical professionals encounter this situation, they're going to go through kind of a layer of trying to find the right person that they're going to choose as your substitute decision maker. So if you are married or have a common law spouse, they're going to really try and find that person to speak with. If not, they're then going to try to find a child who is at least 16 years of age, or a parent. They'll also try to find, next they would try to find a sibling. And if they can't find a sibling, then they would try to reach out to a really close, trusted friend. And if they can't reach that person, then they're going to reach out to more extended family. But ideally, they're looking for the people who or a person who is closest to you.
All right. what is the difference between an attorney, a proxy, and an executor?
Yeah, I'll start off with the executor. The executor is the person who you get to assign to look after. This person's going to be looking after your estate after you have passed away. The other two, the attorney and the proxy, these are people you're assigning to help with some tasks while you are living. So the attorney is the person who you are assigning through your power of attorney document to look after your legal and financial affairs if you are not able to do that on your own. The proxy is going to be helping with your healthcare decisions based on what you have written in the healthcare directives that you've developed.
All right. Well, Hannah, we've come to the end of our time together, but before we go, is there anything you'd like to add that we haven't covered?
Well, I really want to kind of stress the importance of planning ahead for each of these things. And I know that sometimes that can be a little bit scary for some people, but we really want to let people know that sometimes there are actually really simple steps to completing each of these documents. We really encourage people, talk with your families about these things as well. Let them be involved in the communications and inform them about what your plans are. And really to let people know about all of the accessible information that we have on our website. We also have lots of print publications that we can hand out to people. So if people want to contact us at Community Legal Information, they can first have a look at our website, which is www.legalinfopei.ca. You can visit us in Charlottetown at 53 Grafton Street. Our phone number is 902-892-0853, or a person could email us as well, which is info@legalinfopei.ca.
Excellent. We'll make sure all of those, all that information gets up in our show notes. So if people want to look those up later, they can.
That's great.
Well, thank you so much for helping us out today. You've given us a lot of very valuable information, and I know quite a few of us will have a lot to think about.
Sure thing. And I just one piece that maybe I'd like to clarify that should have maybe clarified throughout. But for any of those roles, the executor, the attorney, or the proxy, more than one person can be named for each of those. It doesn't just have to be one person.
Excellent. Well, thank you so much.
Thank you. Have a great day.
You too. So thanks for listening to City of Charlottetown Presents Podcasts for Seniors. Today we've been talking to Hannah Jones, who is Community Liaison with Community Legal Information. So tune in next time when we have some more great information for you seniors.